What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And this time, we may be talking about this case for the last time. Mark Hunt lawsuit against the UFC, Dana White, and Brock Lesnar was dismissed by the District Court of Nevada earlier this week. Now, if you have been following this lawsuit, you will recall that Mark Hunt sued the UFC, Dana White, and Brock Lesnar as a result of losing to Brock Lesnar, the former WWE and maybe current WWE wrestler, at UFC 200 back in July of, I believe, 2016, 2017. Anyway, he claims that the UFC misled him for putting him in a fight with Lesnar, who tested positive for a banned substance. Now, the UFC claimed that Lesnar had no proof and was initially successful in moving to dismiss the charges against all three defendants, UFC, Dana White, and Brock Lesnar, due to the fact that there was no issue of fact at that particular time. A motion to dismiss occurs prior to this fact discovery. So at that point, Hunt's attorneys appealed to the Ninth Circuit Court of Appeal. We wait a while. In the Court of Appeals hears the arguments and overturns the district court's dismissal of the case. Now, it did side with the defendants in some part, but like most of the issues were kicked back down to the trial court. So that's the reason why it had been dormant for a while in our minds, because they had been conducting fact discovery. There was depositions involved, which included, I believe, Brock Lesnar. It did include Dana White, and it did include Mark Hunt. After the fact discovery and those depositions, the defendants once again filed for a motion for summary judgment. So summary judgment happens after fact discovery. Same premise. The defendants believe there was no issue of fact in the lawsuit, and therefore, as a matter of law, the case must be dismissed. Earlier on this week, June 26th, September 26th, the District Court of Nevada finally issued an order siding with the UFC, Dana White, and Brock Lesnar. The primary reason was, as the defendants had been calling all along, talking about all along, as the defendants have been saying all along, Mark Hunt didn't have any evidence that there was fraud to make him fight Brock Lesnar. Now, we won't go over the legal elements of fraud, but essentially, to prove fraud, you must show that you were misled in a way with the knowledge that you were misleading the individual. So the issue here was that that Hunt believed he was led down a path that Brock Lesnar was not taking steroids or any other illicit drugs from Dana White. Now, there was text back and forth, and that was the main evidence, which I felt was problematic. Hunt claimed that these text messages from Dana White assuring Mark Hunt that Brock Lesnar was not juicing, he was not taking steroids, he wasn't doing anything illicit in preparation for that July fight with Mark Hunt at UFC 200. Now, we know that there was an exemption given to Brock Lesnar per the USADA protocol rules, the policy of the UFC allows for exemptions of certain people. So Lesnar didn't have to be within the requisite days to be in the testing pool. In fact, with the early July fight, he was allowed to enter the testing pool in June. Now, the fact issues are this, and this is what the UFC, Dana White and Brock Lesnar had claimed. Basically, Brock Lesnar had tested negative. No banned substances in his body once he was being tested by USADA. So I believe there was 5 or 6 tests that occurred in June when Brock Lesnar entered the USADA testing pool. However, as we found out, the tests that I believe there were 2 in July, 1 in late June, which did not come out until after the fight, which were positive for illegal banned substances, and that's why Hunt started this lawsuit in the first place. Big issues here. The first one that the court decided in the order was that the assurances didn't equate to persuading Hunt to take the fight. The assurances were that Lesnar was being tested by USADA, not that Lesnar would be free and clear of drugs. There was not a guarantee to that as I read the opinion. Obviously, the inference is that the fact that he's being tested all these times by USADA, he would be clean. And in fact, the evidence shows that he was clean in the drug test that started in June. Was there cycling? Was there anything like that? All of that information, factual information, was not considered. The science behind that, whether or not Brock Lesnar had cycled out of something or not, or was taking the illicit drugs at a time where he wouldn't be known to have taken them till after the fight, those facts are inconsequential to this particular order. So the court stated, Hunt and White's contemporaneous communications about the topic do not include any statements that could be construed as assurances that Lesnar was clean. As I stated, White told Hunt that USADA was testing the shit out of Lesnar and that he was not exempted from any testing and that he would be the most tested athlete on the card. None of these statements guarantee any particular outcome for the drug test. So again, like I just said, the inference that Lesnar was guaranteed not to be taking any drugs seems to be the path that Hunt had going into this particular lawsuit, and that was an error. So something that happened at the appellate stage was the question, why weren't the tests expedited prior to UFC 200? Because as we know, the positive test didn't come out until after the fight happened. So, and there is a process where you can expedite the testing. Why didn't that happen? Well, the court indicated that there was no reason to expedite the drug test because the other tests that he had taken were clean. So there was no reason to believe that Lesnar was going to be testing positive. Now, there could be some fallacies in that theory, but that is the theory that the court came up with. So that was the problem for Hunt's case. It rested on a couple home run issues, Hail Mary issues. The text from Dana White. He cited a CNN article that inferred that all wrestlers in the WWE were doping. One single article, and that correlation with Lesnar was incompatible here. It didn't equate at this stage, and so there was no factual evidence that there was the UFC and Dana White committed fraud by misrepresenting or not telling Brock Lesnar. Now, you could definitely say that there was plausible deniability, but that's not a legal theory here. So, what becomes of this particular case? Well, it's over. It's over unless Mark Hunt would like to appeal this particular ruling, which I believe he still can. But just noting this order, it's clear that Hunt had no evidence. So his fraud claims against the UFC and Dana White fell. The civil conspiracy claims failed because there was no underlying cause of action. And we'll get to this point. The battery issue fell against Lesnar. So the issue, which was kind of an interesting issue, was that the fact that Hunt did not sign up to fight a guy who had superhuman strength or was juiced or had steroids or had some sort of performance-enhancing drugs in his system. Did that constitute battery? Because he did not sign up for that. Well, and we went on about this about several cases where, outside the scope of the competitive sport, was there assumption? Did the person that was injured, was there an assumption of the risk? Was there a foreseeability there? These are all legal issues, and the court came up with a couple cases, and their theory it was with these cases that individuals have an expectation of expectation of the risks. If the expectations exceed what has occurred, then there is potential for a cause of action. The courts had indicated that Brock Lesnar didn't do anything at that fight that was outside the scope of what Hunt could expect. So even though he was he was taking PEDs, or he tested positive for PEDs or illegal substance, there was nothing that he did in that fight that was outside the scope of what Hunt could expect. So he didn't hit him with a chair, he didn't throw him outside the ring, he didn't pick him up and do anything illegal, he didn't do anything outside the realm of the rules of the UFC Combat Sports MMA. Now, if that was therein the problem, because also Hunt had indicated that he didn't believe at his deposition, he didn't believe he was hurt in any way outside the scope of how you could be hurt in an MMA fight. So the court believed that there was no battery claim because Hunt's expectation of risk was not exceeded. So that's an interesting theory that could go on to torts in sports, things like that. When you think of beanball incidents, which is actually a big case in California, they decided that there was a case that they cited in this court order with a mechanical bull that they use at bars, and people would get on it, but they amped up the bull so it was bucking really hard. People got injured. That's a case. So it's again exceeding the expectations of the risks. Interesting for legal guys like me. But as far as Mark Hunt goes, his case should be over, and this case is probably closed. And that probably is fair to say. I think that there were lots of nuances in this particular case, a lot of things that could be taken from it. But again, as many people probably thought, this was a long shot for Hunt to win. The appeal kind of buoyed his hope that they could settle. I'm not sure how much they were close to settlement, but in the end, there's nothing at the end for Mark Hunt. Well, that's it for today. It's Jason Cruz with the Legal Submission. Like the video. Please subscribe to the YouTube channel. Please subscribe to the Substack. And visit MMA Payout Daily for the most up-to-date stuff in business and legal aspects in combat sports. Have a great day.